Hey everyone, it's Darren here, constitutional lawyer, here to bring you an update on a new case we're working on. It's out of a small town called Springfield in Manitoba, and it deals with important issues of freedom of the press and freedom of expression pertaining to recording of meetings of town council. So what happened in December of last year was that the Springfield Town Council passed a new bylaw that stated that media required 48 hours notice to record open meetings of town council. Now, interestingly, the bylaw doesn't say anything about what the public has to do to record meetings, and it doesn't say that the public is not allowed to record. So, in February of this year, residents started recording a delegation from one of our applicants, Dr. Daniel Page, and she recorded for about 15 minutes without anyone even saying anything until the mayor asked if she was recording and asked her to stop. And the mayor claimed that the new bylaw prohibited the public from recording and that only the media was allowed to record. So we've brought this new case forward on behalf of 4 residents of Springfield who think that this is an important issue, who want to improve transparency and openness in town council meetings. So the importance of this case is that it's a pretty novel issue dealing with Section 2B of the Charter, freedom of expression, and freedom of the press, which is kind of a very underutilized, underexplored part of the Charter. And one of the main issues we're dealing with here is that recording itself has been found to be an expressive activity. And of course, we're living in a day and age of the citizen journalist where people can just pull out their phones and start recording things. So it's quite concerning to us that many town councils think that they could just ban recording altogether because they just don't want people to see them. So I guess that's kind of the issues at hand. And so our 2 arguments are actually on this case is that, one, the bylaw actually doesn't say anything about prohibiting recording, so the mayor couldn't just arbitrarily do this. And 2, like I said, even if the bylaw does prohibit recording, then it's a breach of our applicants' charter rights because they have a right to record these sessions as long as they're not being disruptive. So hope this was interesting to you, and follow jccf.ca for more updates on this case and other cases. See you guys.